Thank you. Lord Foster, final supplementary to you.
I just want to pick up on some of the remarks you were making earlier about the way in which the case against big tech firms have sometimes failed. Your argument, Dirk, is the solution to that, as I understand what you're saying. It's vital that we have explicit, quantifiable rules and that cases brought are then evidence-based. Yep. And I think, certainly, I suspect many of us would agree with that. But I've done a lot of work on gambling legislation. And the gambling companies in the UK make £14 billion profits a year. They've got tons of dosh, and they can use that dosh to employ the very brightest and best minds to develop new products and get round, in inverted commas, whatever rules there are, putting the regulator at a disadvantage. Presumably that's always going to be the case in all jurisdictions. Is there any solution other than the one you've offered?
I think competition law and antitrust, for all the negative that's been said about them, have actually proven extremely resilient to get at these issues. Like the first way that cases were brought against the big tech platforms were competition law and antitrust. And I think competition law, because it relies on these very broad principles, has that flexibility. I think it is one of the downsides of regulation that inevitably firms will invest huge amounts of money to try and be not regulated, and that cuts against regulating. But yeah.